So what happens if someone passes away in California without a will? The American Bar Association tells us that 1/3 of all American millionaires die without a will or an estate plan in place. Here's what happens. Anytime an estate owner passes without a will in California, the estate goes to probate court, and probate law is applied without any consideration of what the estate owner's desires would have been. There's just no way the court could know. One thing is likely, though, that a complicated legal mess will occur. Attorneys' involvement and their aggressive fees become necessary, which adds to the costly, time-consuming probate court experience that can take many months and sometimes several years. Conversely, assets owned through a living trust do not need to be probated. Now, probate laws do attempt to get it right, but they never really can, because all estates and family dynamics differ so much from each other. If a decedent's wishes are not documented in advance, assets can go to the wrong people, and very often the right people are not considered to be heirs. One example of how probate law misses is Prince, who we all knew, passed away in April of 2016 without even a simple will, though he really should have had an estate plan. Now, Prince wasn't married and had no kids, so probate law stipulated, in this case, that Prince's assets should be divided equally by his siblings. Well, Prince had only one full-blooded living sister and 5 half-siblings, some of whom he may have never even met. Prince was also religious and involved with his church and may have wanted some money to go to it, which will not happen. And to make matters even worse, the court battles may continue forever with about 24 lawyers and their charges involved. Now, Prince had a large estate, of course, but we're certain that what is happening to it is not at all what he would have chosen. The reason we share this story with you is to illustrate what can happen and how avoidable it is. So imagine, if a probate court judge could have just 5 minutes and could ask any decedent, what would you like to happen to your specific assets, and who would you like each asset to go to? Matters could then become resolved easily because the estate owner's desires would then be crystal clear. And that is really all a will is, your chance to tell a probate court judge in advance that if anything should ever happen to me, then this is what I would want to occur. Then the court's job becomes to enforce your wishes and not just to interpret how probate law would apply in your case. That is a huge difference. So please seek solid financial and legal advice, document your desires in advance, and have your will and estate plan prepared. It is so simple and so important. Now, this is general information only, is not legal advice, and should not be treated as such. However, we at Kubler Financial would like to explain further how you can avoid this type of mess, to enjoy long-term security and peace of mind, no matter what. We encourage you to contact us for more information. Clicking the Learn More button in about 5 seconds will take you there. As you know, taking action and being proactive almost always makes the difference. Thanks very much, and have a great day.